Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, I'm going to preview a case called City of Hays, Kansas v. Vogt, which is going to be argued on Tuesday, February 20th, 2018. Now, this case, City of Hays v. Vogt, is about the Fifth Amendment's right against self-incrimination. The Fifth Amendment, among other things, it says, "No person shall be compelled in any criminal case to be a witness against himself." And this is familiar to most people as the right to remain silent in the famous Miranda warning, and also the idea of taking the fifth to avoid testifying. The core idea here is if you're a criminal defendant, you can't be forced to take the stand and testify in your own trial. But also as a kind of a corollary to that, you can't be forced before trial to give testimony that will later be used at trial. Otherwise, the right could be easily circumvented and wouldn't mean much to be able to refuse to take the stand if you could be questioned prior to trial, and that could be admitted in the trial. So as a result of this, if someone is compelled to talk to the police, if they're coerced or forced to give statements to the police, then anything they say can't be admitted at their trial. A lot of cases about the self-incrimination provision of the Fifth Amendment, a lot of the cases are about voluntariness. They're about whether a person was coerced into speaking with the police or whether they did so of their own free will voluntarily. That's not the issue in this case. Here, the parties are assuming that the statements were compelled by the police. But the question here is about where those statements can or cannot be used without violating the Fifth Amendment. That brings me to a common misconception about the Fifth Amendment. The Fifth Amendment doesn't necessarily prevent coercing or compelling someone to talk. For example, if there is no possibility of future prosecution, then there is no privilege against being compelled to give statements. For example, if the crime that's being investigated, if it's already past the statute of limitations, or if someone's already been acquitted of a crime and double jeopardy would prevent them from being retried, or if they've been pardoned or given a grant of immunity for their testimony, then there is no privilege against self-incrimination. What the self-incrimination provision of the Fifth Amendment does is it just prevents any compelled statements from being used against in a criminal trial. And let me get into the facts of this case, then it'll become more clear what the issue here is. So it's called City of Hays v. Vogt, and Matthew Vogt was a police officer in Hays, Kansas. And just as an aside, the facts in this case, this case comes to the Supreme Court from a motion to dismiss in the lower court. And on a motion to dismiss, this is at an early stage in the proceedings, and the facts have not necessarily been fully fleshed out. And on a motion to dismiss, the court is deciding based on the facts as they're alleged in the complaint in the case. And in this case, it was a civil complaint by Matthew Vogt against the city. And so these are the facts as they were alleged in his complaint. And a lot of them are somewhat vague and unclear. You'll see as we go along. But those are the facts as the case comes to the Supreme Court. So Vogt was a police officer in Hays, Kansas. And in the course of his duties as a police officer, he obtained a knife and that he kept for his own personal use. Now, this is at one point, the briefs are very vague about the circumstances. They don't really explain how he came to have this knife or what the exact importance of this is. According to the government's brief in this case, the federal government's brief in this case, apparently he was investigating a vandalism complaint about a car with slashed tires, and somehow in the course of that obtained this knife. But that's just as recounted in the government's brief. At some time later, he applied for a job as a police officer in Hayesville. Now, this is a different town. He works as a police officer in Hayes. He's applying in Hayesville, similar name, different town. In the course of interviewing for the position in Hayesville, he told the interviewers about this knife, about obtaining this knife and keeping it. He as a result of this, he was given a job offer by the city of Hayesville, conditional on him self-reporting to his current police department in Hayes this situation with this knife. So Vogt did that. He reported to the chief of police in Hayes about obtaining this knife and returned the knife to the police department. And what happened then was the police chief opened up an investigation of this knife situation. They asked Vogt to document how he obtained this knife. He gave a vague one-sentence statement and also tendered his resignation, gave his 2 weeks notice that he was leaving the police department. He was ordered then by the persons that were put in charge of investigating the internal investigation. He was ordered to provide more information about how he got this knife. He apparently explained only the type of investigation that was involved when he acquired it, but from that they were able to identify video footage of the time when he acquired the knife. Now, I apologize for all the vague statements in the about the facts here, but that's actually all there is in the briefs based on his complaint. It doesn't really go into any details about exactly how he got this knife or what the problem with it is. In any event, after obtaining this video footage, the investigators in Hayes Department reported this situation with the knife to the Kansas Bureau of Investigation. The Kansas Bureau of Investigation opened their own criminal investigation and eventually charged him with 2 felonies related to this knife. And again, the briefing doesn't explain, and his complaint doesn't explain what those felonies were, just 2 felonies related to his acquiring this knife during his police duties. So he was charged with 2 felonies. And what happened next was a probable cause hearing was held in the criminal proceeding on these 2 felonies. And the probable cause hearing, it was something that was required by Kansas state law, and these are common in a number of states. And what it is it's an early hearing where the prosecution has to present evidence to a judge to demonstrate that there's at least probable cause to allow them to go forward with the criminal prosecution. So it's just an early stage hearing to make sure that there is some basis for a criminal charges to go forward, so they can proceed through the normal process and eventually to potentially go to trial. At this probable cause hearing, the statements that Vogt made to the investigators at the Hayes Police Department were used against him at this probable cause hearing. And again, not clear exactly how these statements were used against him. That's not specified in any of the briefings, but just assuming for the purposes of this case that those statements were used against him at the probable cause hearing. Now, the charges were later dropped. So this criminal investigation, the criminal prosecution went away. That's gone. However, at this point, Vogt had resigned from the Hayes Police Department, and Hayesville, where he had been applying for a position, they withdrew their job offer after the criminal charges were filed. So he was left significantly worse off after this whole situation with the knife and the criminal investigation. So what happened is, after the dismissal, the dropping of the charges, and his criminal case went away, he ended up filing suit against the city of Hayes. He also filed it against individual police officers involved in the investigation, and also Hayesville, the city where he was trying to get the job. But they were dismissed out of the case later, and they're not relevant to the case as it goes to the Supreme Court. The only issue at the Supreme Court is the city of Hayes. And he brought a claim for a violation of his Fifth Amendment rights, and saying basically that by threatening to fire him if he didn't cooperate with their investigation, so if he didn't provide those statements explaining how he came to have this knife, that was compelled self-incrimination. And then the use of those statements later at the probable cause hearing constituted a violation of the Fifth Amendment, because by using those statements at the probable cause hearing, he had been compelled to be a witness against himself in a criminal proceeding. So those are the facts there. So before I get to the specific arguments that are in play in this case, I'm going to step back to a precedent, a key precedent that this case follows from. There's a case called Garrity V New Jersey, and it's a 1967 case. And the facts are somewhat similar to this case. It involved an internal police investigation. In that case, it was a ticket-fixing scheme. And there were 6 officers involved who were, in the course of this internal investigation, they were informed of their right to remain silent, so that the familiar Miranda right. But they were told that if they did not cooperate with the internal investigation, they would lose their jobs. The officers did cooperate. They provided statements to the investigators, and those statements were later used against them at a criminal trial, and they were convicted. And the case from there went all the way up to the Supreme Court. The Supreme Court reversed the conviction and said that this was compelled testimony, said that by making them ordering them to cooperate with the investigation on penalty of losing their job, that was compelling their testimony, and then later using that at a trial violated the Fifth Amendment rights, so the conviction was overturned. The result of this case, the Garrity v. New Jersey, is that a common practice in many government jobs is something known as a Garrity Warning, which is similar to the Miranda warning. It's a warning given to government employees involved in internal investigations, where they're advised of their right to remain silent, but also advised that they can't be fired for invoking their right to remain silent. So that's the Garrity case that's in the background here. So what's the difference between Garrity and this case, this City of Hayes case? The big question is, does the Fifth Amendment protection only apply when statements are introduced at trial, or does it also cover the probable cause hearing? Because here there was no trial. Vogt was never put on trial because the charges were dropped before it ever got to that point. So the argument here, the city says that that it's just a trial right, that the Fifth Amendment's protection against being compelled to be a witness against oneself is a trial right that means in the actual criminal trial where the guilt or innocence is going to be determined, the statements can't be introduced, but that it doesn't apply in other proceedings, earlier proceedings, and in the case. And Vogt argues the opposite, that it should apply equally at these preliminary types of hearings. So let me, with that kind of context, let me dig into some of the specific arguments that each side is making in this case. So they both focus on the language of the Fifth Amendment, but they put emphasis on different parts of the different sets of words in the Fifth Amendment's language. The city argues that the phrase for someone to be a witness against himself, so that someone not be compelled to be a witness against himself, that refers to statements being introduced at trial, that someone has not been made a witness against himself until testimonial statements have actually been introduced at trial. And in support of that, the city points to some Supreme Court precedents that explicitly refer to the Fifth Amendment as a trial right and say it's only violated when things are introduced at trial. Now, those cases, as the city admits, are not directly on point because they weren't cases that were kind of distinguishing between trial and pretrial proceedings. But at least there's a lot of language in previous cases out there that kind of seems to support the city in that sense. But the city also notes that there are other types of pretrial hearings where there seems to be broad agreement that the right against self-incrimination doesn't apply. One is grand jury proceedings, which are proceedings held in federal courts and in some state courts, which where a grand jury will hear evidence and decide whether the evidence is sufficient to have a criminal, to begin a criminal prosecution, and there's precedent that incriminating statements can be that the fact that a compelled statement is introduced to the grand jury is not grounds for reversing a conviction in a criminal trial. Also, competency hearings, where a court determines if a defendant is competent to stand trial, those also the statements that were potentially compelled can be introduced. So they have some arguments on that side. Vogt focuses on a different set of language. He focuses on the fact that the Fifth Amendment text, it says that these protections, the self-incrimination protection, applies in any criminal case. And he argues that the probable cause hearing is part of the criminal case. It doesn't say any criminal trial. It refers to the case, and the case is much broader than that. And Vogt goes on to argue that the probable cause hearing is an incredibly important part of the case, because it's kind of the first hurdle where if the government is not able to meet its burden at the probable cause hearing, that's the first time that the case can completely go away. And in some cases, it can arguably be the most important part of the criminal case, because it's at that point where the defendant has an opportunity to get the case dismissed if they can show that there isn't sufficient probable cause. And once you're past the probable cause hearing and the government's case survives, and they say that the court finds that there is probable cause to continue, at that point, the overwhelming majority of cases will eventually come to a plea bargain and will never reach the trial stage. So once that one hearing can be, in many cases, the kind of last chance to get out of a criminal charges without ending up in a situation where a defendant feels that they need to take a plea. Also, Vogt argues that the probable cause hearing, the probable cause hearing and other proceedings, other hearings and things, and just the process prior to trial can still inflict a great harm on a defendant. So someone who is charged and has a probable cause hearing, and the case goes forward, and they may be detained pending trial, there may be enormous harms to someone's career, to their freedom if they are detained, and just to their life and ability to go about their business, even if the charges are eventually dropped and it never goes to trial, or it goes to trial and they're acquitted. There's great harm in that, and so any protection against or constitutional protection should apply at that early stage and not just at the end of the line. So those are some arguments on that front. I mentioned that the city notes that the right doesn't apply before in grand jury proceedings. And the city points out that the probable cause hearing is, in many states, it's kind of an alternative to a grand jury. States that either don't use the grand jury or have probable cause hearing as an alternate path instead of a grand jury, so that it's the way a criminal case really gets kicked off. It's the method that many states use to ensure that there is some basis for allowing a case to proceed. And if the right doesn't apply before the grand jury, then why should it apply before these other probable cause hearings? And the city further notes that there's some states, a few states, that don't even hold these probable cause hearings, where just the filing by the prosecutor, who the prosecutor's determination just on their own that there is probable cause, and the filing of an information against the defendant is enough to kick off the case even without any probable cause hearing. And given that the state doesn't even have to have this probable cause hearing, the fact that they voluntarily provide one, it shouldn't be constrained by these by some constitutional prohibitions on introducing certain types of evidence. Vogt, on the other hand, argues that the difference between the grand jury and these other proceedings is that the grand jury proceedings are before a criminal case has begun. The criminal case only begins once the grand jury decides that the case can go forward. But at that point, you have a criminal case, and that's where the protection attaches. On the other hand, a probable cause hearing happens after the prosecutor has already initiated the case, and it's just an early stage. But that's once the case is already underway. So just on the formal language of in any criminal case, Vogt argues that should cause the probable cause hearing. The city has another argument. It compares the application of this rule, which again the city says should only apply at trial and not at earlier proceedings, to two other constitutional provisions, Bill of Rights provisions, the Confrontation Clause and the Compulsory Process Clause. And these are Sixth Amendment rights. And the relevant language says, in all criminal prosecutions, the accused shall enjoy the right, at first, to be confronted with the witnesses against him, and second, to have compulsory process for obtaining witnesses in his favor. And those are rights that protect a defendant's right to cross-examine witnesses, to actually have witnesses take the stand and be able to cross-examine them and question them about what they're testifying to, and also the right to have the court issue subpoenas to compel witnesses that the defendant believes will be favorable to the defense, compel them to attend the trial so that the defendant has witnesses in his or her favor. And in both of those rights, both of which refer to witnesses, and specifically in the Confrontation Clause, witnesses against him. They use the phrase witnesses, but the cases have interpreted that to only apply at trial. That you don't. Confrontation right does not necessarily apply to earlier proceedings, and the compulsory process, the right to subpoena people and to have people attend, does not necessarily apply pre-trial. So the city argues that it's the same language. It should follow that the same thing applies when you're talking with the self-incrimination clause. There's a few more arguments. Vogt refers to the history of the Constitution, the Bill of Rights, the drafting of the Bill of Rights, and notes that the abuse of compelled speech in pretrial proceedings was something known to the framers of the Bill of Rights and something that they were well aware of. There were some well-known and notorious cases of people being compelled to testify in what would be the equivalent of these kind of pretrial proceedings that were seen at the time as abuses. And so the argument is that the framers of the Bill of Rights would have wanted to cover these early proceedings as well, since this was a known concern about compelled speech. The city argues that this kind of misstates where the concern was, that the concern was about this kind of compelled pretrial testimony later being introduced at the actual trial and used against the defendant. So that they have a different take on the significance of that history. And Vogt also argues that the implication of the city's position, if the Fifth Amendment self-incrimination clause doesn't apply at these pretrial proceedings, like the probable cause hearing, that the state would actually be able to compel a defendant, compel Vogt or some other defendant to take the stand at the probable cause hearing and actually testify there in court, which seems to run directly against the normal conception of what the self-incrimination clause is supposed to prevent. The city counters that no, because at that point he could invoke his Fifth Amendment right against self-incrimination, saying he refused to testify because it might incriminate him, which you're allowed to invoke that right to protect against the later use of statements in a criminal proceeding. So they argue that there wouldn't really be that kind of ugly outcome, or outcome that looks counter to the I guess the primary function of the self-incrimination clause. Vogt also points out that the self-incrimination clause applies at some post-trial sentencing hearings. He argues that the city, under the city's view, it's confined just to trial, but at sentencing hearings where a judge is going to determine the sentence that a defendant who's already been found guilty is going to face, the confrontation clause also, or the self-incrimination clause, has been held to apply and prevents the introduction of compelled statements. The city argues on their side that this is because sentencing is really bound up with the trial, that sentencing and the trial are really two parts of the same process, that the determination of guilt and the determination of the sentence that the guilty party is going to receive are all of a piece, and it's just the fact that they've kind of been separated into two different proceedings, separated in time, doesn't change the fact that they're really all part of what the trial process is about, not just determining guilt and innocence, but determining the sentence that's going to be imposed. So those are the main arguments on the language and the purpose of the Fifth Amendment's self-incrimination clause. But there's also some policy arguments that come into play. The city makes a few arguments about why their position would be better as a policy matter, would make more sense. And one argument is just that the Fifth Amendment, the city argues, it creates a particular problem for police departments investigating criminal misconduct. When you have a police department that's investigating, it's engaged in internal investigation, they're not only investigating their own workplace for workplace misconduct, but they're also the ones who are tasked and in charge with enforcing the criminal laws. So you have kind of these dual purposes. And when when information that they would want to receive in one capacity will restrict their actions in the other capacity, then it creates problems. Now, if you had a private business that had reports or concerns about employee misconduct, they could have an internal investigation, require the employee to participate in the investigation, potentially on penalty of losing their job if they refuse to cooperate. And they could also turn any information that they learned over to the police if there was criminal conduct that they wanted investigated by the police. And there isn't an issue there because the entity that's doing the investigation isn't the government. They're not using the government power to force someone to put someone to that choice. But when it's the police department and they're the same ones that are investigating and prosecuting, or investigating criminally and investigating for purposes of workplace misconduct, you have another bigger, more entanglement, I guess. Vogt argues that this is really not a concern, and that many jurisdictions, the federal government and many jurisdictions across the country, have already taken steps to address this. And there's many things that can be done. For example, by segregating criminal investigations from internal affairs, having different personnel and potentially in different offices, but at least different personnel dealing with those investigations and kind of firewalling between them so that information that is obtained during an internal investigation doesn't get passed across to the criminal investigators and then used in violation of these Fifth Amendment rights. And they note that the federal government does this extensively and has procedures in place to prevent this kind of contamination. And there may be the possibility of granting immunity to certain people to get the information from them, but granting immunity meaning that information that they provide in the course of the investigation won't be directly used in a criminal prosecution. And that's another technique that the federal government uses often. Another policy argument that the city makes is that requiring these kind of Fifth Amendment determinations for pretrial proceedings are just, it's not practical. It would slow things down. These determinations of whether a statement had been compelled such that it would implicate the self-incrimination clause can be very fact-intensive and would require taking of testimony and other evidence. And some of these early proceedings, for example, a probable cause hearing to keep someone in custody, or bail hearings, they're the types of hearings that need to happen very quickly after someone is arrested, and courts are they're set up to try and run through these very quickly and without spending a whole lot of time on digging into these kind of details. And so courts just aren't set up and aren't prepared to deal with detailed evidentiary matters, fact-intensive questions at this early stage in the case. When you get to trials, it's normal for trials to have extensive motions prior to trials where the parties argue about what evidence can and cannot be admitted in trial, what evidence must be excluded. And that's a natural time when a court could decide that certain statements can't be introduced because of the Fifth Amendment's protections. But the city argues the early stage, when you have a probable cause hearing and other early pretrial proceedings, it's just not realistic. Vogt argues, on the other hand, that, first of all, sometimes just abiding by the Constitution's protections requires more procedure. It requires courts and other government bodies to engage in more extensive procedures and which sometimes have more time and expense involved in them, and that's just the cost of having constitutional protections. And Vogt also argues, though the city disputes this, but argues that it's been very manageable in a number of the circuits. So this is the circuit courts of appeals have already followed this rule, because there is a division between the federal courts of appeals on whether they have held that that the self-incrimination clause applies in these types of probable cause hearings. And Vogt's argument is that in those circuits that have held that it does apply, there hasn't been chaos or difficulty in applying it. They've managed. And the city argues, on the other hand, that these cases, it just hasn't been on the radar enough for there to have been many cases yet, but that this case could open the floodgates to numerous claims of violations of the Fifth Amendment right in these kinds of pretrial hearings, and then that would result in lots more motions to exclude statements from these pretrial hearings, which would kind of gum up the works and cause a huge problem. So that kind of sums up most of the arguments, the main arguments that the parties are making on the application of the self-incrimination clause to the probable cause hearings. There is another interesting, it's kind of a different angle on this that was raised by one of the amicus briefs, but also the city kind of endorsed it as well. And it's a slightly different question, and it's a question of whether a municipality like the city of Hayes can be held liable at all for statements that the state introduces in these criminal proceedings. And the issue here is that, as I mentioned earlier, normally a Fifth Amendment violation requires two parts. It requires, first, that there be some compelled statement, some compelled testimony or other statement, and second, that be introduced in some criminal proceeding. And the first alone is not a violation of the Fifth Amendment. Just the fact that the speech has been compelled from someone, testimony has been compelled by someone, does not amount to a violation unless it's later used at a criminal trial. And normally, when Fifth Amendment issues come up, it's in the context of a criminal prosecution, where the question is whether, first, whether certain speech must be, if it's before the trial has occurred, it's the question of whether certain statements should be excluded from the trial and should not be allowed to be relayed to the jury. And second, if it happens after the trial, if there's appeals attacking the trial on the grounds of a Fifth Amendment violation, then the question is whether you need to provide a new criminal trial because the trial was tainted by these unconstitutionally admitted statements. But here we're in a totally different context. Here we're in the context of a civil suit asking for money damages for the violation of a right. And the city argues a couple points here, that first that it doesn't make sense when for the city to be liable for compelling these statements when it was the state, not the city. It was the state, the prosecutors who made the decision to introduce these statements at the probable cause hearing. So the city had no control over whether the prosecutor was going to introduce these statements. So how can they be liable when that was what really caused the violation to occur, the introduction of it in the criminal proceedings? Vogt argues that there's still responsibility on the part of the city in that they passed along these statements to the Kansas Bureau of Investigation. So they were responsible for not only getting the statements from Vogt, but also forwarding them on to the authorities that eventually prosecuted him. So he argues there should still be liability there. The city argues to the contrary, saying that here the city isn't really responsible for that, because basically Vogt made the initial report completely on his own to the city of Hayes, telling them about this situation with the knife, and that was enough for the city to have reported to the Kansas Bureau of Investigation, regardless of whether they'd gotten those later statements from him. So that would have initiated that and kicked it off regardless. That's a kind of a specific factual detail about this particular case. And this whole issue of the money damages versus a remedy for its introduction, it kind of points out a very important difference between the Fifth Amendment right against self-incrimination and the Fourth Amendment protections against unreasonable search and seizure, which is structured very differently. Under the Fourth Amendment injury is complete as soon as an unconstitutional search is made. If someone's home is searched or they're searched and in violation of the Fourth Amendment's protections, then it's irrelevant whether the results of that search end up being introduced at trial or not. As soon as the search is done, that's where the violation has occurred. And that's very different from the Fifth Amendment. So in the Fourth Amendment area, as long as an illegal search has occurred, there's a potential, at least, for damages for civil liability for damages. Whether or not there may be a remedy in a criminal prosecution to exclude evidence from an illegal search, the Fifth Amendment, on the other hand, is kind of the reverse. Since it's the introduction at trial that causes the violation, it's much clearer that the exclusion of that evidence from trial is an appropriate remedy, and much less clear that the initial compulsion of testimony should give rise to liability. And the city raises, in this case, City of Hayes raises the prospect that every single, for example, failure to give a Miranda warning to a suspect could potentially subject that officer or the city to liability, money liability, regardless of whether the statement that's given ends up being used at trial at some later date, and that would be a huge change to the current state of affairs. So that's kind of the rough summary of the issues, the arguments that are at issue in this case. And again, that's going to be coming up on February 20th. The Supreme Court will be hearing that case, hearing argument in the case, and the decision, as with all of their cases in the term, the decision will come down sometime by the end of June. But when is anyone's guess. So that's it for this episode. Please subscribe to Counting to Five on YouTube or through your audio podcast app of choice. And for timely coverage of the latest developments of the court, please check out Counting to Five's weekly YouTube live streams. In those live streams, you can ask your own questions in the live chat, and I try and summarize all of the latest happenings at the court, what's been going on in the previous week or so. And these are currently being broadcast. Our regular time is Thursday nights at 9 p.m. Eastern Time. But you can always check the Counting to 5 YouTube channel to see when the next scheduled live stream will be happening. I'm always looking for feedback. I'd love to hear what you think about this or any other of our episodes. Please leave me a comment or send me an email at mike@countingto5.com. And thank you for listening. This has been Counting to 5.